My name's Harriet Wistrich. I'm a lawyer, a solicitor. I've been working in the field of, kind of challenging the police and other state bodies for a long time, and in a legal aid firm. And in the last 3 years, I've set up the Centre for Women's Justice, which is an organisation, legal charity that holds the state to account on violence against women and girls. Well, I mean, most UK lawyers don't really use CEDAW or even know what it is. What we try to do with cases that are going to court is if they engage the issues in CEDAW is to kind of reference it in the pleadings at the very least, or to if you're making submissions and you think that CEDAW is relevant, just to quote it or reference it. And sometimes it becomes part of your legal case in court. So that's the first way. And then recently I've looked at whether there's a way of using the optional protocol to make a complaint arising from a case or a series of cases. And so we put in quite a detailed submission in relation to the issue of undercover police officers who have deceived women into long-term intimate sexual relationships. And we put together a whole submission about that, and we then are waiting for that to go through the process to see whether it's deemed to be admissible, and if it is, the government have said it's inadmissible for various reasons. We've argued against that, and it will be going before the committee. So it's taken about 2 years already just to get this far. We're hoping that it will be ruled admissible, but there are arguments why they may say it isn't. If it is, then there's the next stage of actually considering the substantive application. So basically, I mean, CEDAW is a very broad-based human rights convention. It's the only one that focuses specifically around women, discrimination against women, and it's got some very interesting kind of articles which are kind of give you a bit more scope as a lawyer to use some of the arguments that other legal conventions don't have. For example, the whole prohibition on gender stereotyping and cultural beliefs is something that is kind of quite a lot more advanced in thinking than you'll get in, for example, the European Convention on Human Rights. So it offers a way of kind of bringing challenges that kind of deal with additional issues. And so, we've used that, we've kind of referenced it in relation to in the challenge around the John Warboys, who was a black taxi driver who went on to assault 100 plus women by drugging them. And I had brought a case. It started quite a number of years ago on behalf of 2 women who were his victims, and they brought a case against the police because they felt that the police had failed them, and had they properly investigated, he wouldn't have gone on to commit so many assaults. In the case was challenged. We won all the way actually, but the police tried to appeal it at every stage. And when it got to the Supreme Court stage, a coalition of women's organisations, including End Violence Against Women Coalition, Red Crisis, Southwark Black Sisters, the NIA Project, came together to put in submissions specifically looking at the wider issues arising from that case. And in those submissions, they relied on CEDAW and also the Istanbul Convention, and kind of made a lot of submissions around that. So that's one example. The other example, which is a case which is at an earlier stage at the moment, but it relates to the issue of women who have lots of convictions for soliciting, usually women who've been sexually exploited, often as children, teenagers, who've ended up being put on the streets and then arrested repeatedly, as you are. Lots and lots of criminal convictions. They've exited prostitution many years ago, but if they want to apply for certain types of jobs or certain types of voluntary activity, they're required to disclose their criminal convictions, and we say that that is entirely wrong and it is contrary to CEDAW, amongst other things. And we argue that in our legal case, and interestingly, when we went, I was able to go with the whole UK NGO group to Geneva to kind of make submissions about their report and concluding observations on the UK. And although there were individual groups from there's a highly polarised debate around whether prostitution should be decriminalised altogether, not just the women but everybody else involved in the industry, the exploiters and the men who use prostitutes, and certain human rights organisations seem to think that that's the right way forward, and then a lot of feminist organisations support variations of the Nordic model, which says the women should be decriminalised but not the men, and not in fact the men should be criminalised, and so should obviously the exploiters, the pimps and so on. Now, although there's this very polarised position, there is one bit of common ground, and we were able to work with both sides of the divide to agree put very strong submissions in about why women should not have to have their criminal records disclosed after, and that in fact that those sorts of offences should be decriminalised, and that was a concluding observation, so that was quite a successful outcome. Well, it's something that's been recommended again and again by the CEDAW committee, and it would be amazing if it was incorporated from a legal point of view. Be incredibly useful. Although there are arguments that isn't necessarily the kind of primary objective. What we've got to do is just get the UK government to abide by that. I think there's some academic arguments that you don't necessarily even need to incorporate it, but there just needs to be this kind of taking into account. But I think incorporation would be very useful. I thought Rosie's talk was very interesting about the kind of just bringing CEDAW right down into common language and getting everyone kind of familiar with it as a human right, as a way of expressing women's rights as human rights, and getting it not just amongst lawyers. I obviously look at it particularly from a legal point of view, but I think it should fall into our everyday language, and once it's there and it's fully part of our a major part of our feminist language, that gives options as well.